The person at the jail, please state your name for the record.
Todd Burns.
This is case number 253733 FT, the people of the state of Michigan versus Todd Allen Burns. We are here for an arraignment. Mr. Burns, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, Your Honor.
Did you also have the opportunity to meet with somebody from the Public Defender's Office today?
Yes, Your Honor.
I have a complaint that alleges that between the dates of July 17th, 2025 and July 25th, 2025 in the city of Cadillac and Wexford County, it is alleged in count number 1 that you committed the offense of motor vehicle unlawful driving away. That is a felony punishable by up to 5 years in prison. Additionally, the prosecution has opted to charge you as a habitual fourth offender. That means that you have at least 3 prior either attempted or completed felonies in your past. That makes that 5-year felony a 15-year felony. Do you understand those? I'm sorry, it makes that 5-year felony a life offense. Do you understand those charges and the potential penalties?
I understand what you said, Your Honor. Yeah.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and the right to stop answering questions at any time. You also have the right to have an attorney present during all phases throughout this process. And if you could not afford one will be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
As we have a request the help of Mr. Harrison, public defender.
We can't guarantee it'll be Mr. Harrison, but we can make a referral to the public defender's office for the appointment of an attorney. So we will make that referral. We'll enter a not guilty plea on your behalf, and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause of the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. However, if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel in 04, I showed an operating while intoxicated, an attempted larceny in a building. In 07, a malicious destruction of property. In 13, an attempted assault and battery. In 16, a resist and obstruct and an OWI. In 18, actually 2 child abuse 4s, an OWI 3rd, and in 22, a driving license suspended and a high back 2nd. Looks like he was released off probation on August 22nd of 24, and the praxis scores him at a risk level 2. Any comment regarding bond, Mr. Harrison?
Well, in addition to all of that, the fact that he was able to complete probation, he owns the house, the address that he provided. He is gainfully employed in a variety of jobs. He not only works at the Bourbon House, he has a real estate brokerage practice and has substantial ties to the community. It's my understanding that the vehicle in question, there's a dispute as to the ownership of the same between Mr. Burns' former significant other and her new significant other. So it's not just your ordinary run-of-the-mill, found the vehicle and drove it away. The parties all know each other as far as I know. I don't see any risk in releasing him PR here, although it is a felony charge, as you've described, Your Honor. He's never shirked his responsibility for appearing in court. I believe he had one. I've represented him in his most recent case, and I believe he had 1 failure to appear, but it turned out that was due to a mix-up in the notice being sent to him or some procedural difficulty, and we rectified that right away. Like I said, I think he's a good candidate for PR. Thank you.
Thank you, Ms. Lawrence.
Thank you, Your Honor. Mr. Harrison is right in the respect that this vehicle used to be owned by the defendant's ex-girlfriend. But in this case, that ex-girlfriend actually sold the vehicle to her current boyfriend. He had a title for the vehicle. I believe the defendant was aware that he did not own this vehicle. Police actually made several attempts to get in contact with Mr. Burns to retrieve the vehicle, and he essentially, for lack of a better term, evaded them for quite some time and refused to hand the keys over to the vehicle, which never belonged to him in the first place. I do think, given his criminal history, a small monetary bond may be appropriate, as well as this is a pretty high-level felony, given the habitual fourth offender. So I would ask for some type of monetary bond. I would also ask for a no contact order with the victim. Thank you.
My reading of the probable cause affidavit was that the vehicle left at his house, and then in between time, the girlfriend deeded it or titled it to someone else, and then he drove it, and eventually it was abandoned in a parking lot. Am I correct on that?
Correct.
At least according to the probable cause.
Yeah, that's. That's.
Your Honor, I mean, I've been paying my child support every week. My children really need me out there working so I can continue to pay my child support. All I do is work and go home. That's it. I came in here with a few $100s that I could bond out with if you allow it.
All right.
He does walk to work at the Bourbons. I've seen him.
Ms. Lawrence, are you requesting a no contact with the new owner of the vehicle, or Russell, or the girl, the ex?
It would be Russell, Your Honor.
All right.
I don't speak to any of them.
All right, Mr. Burns, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no crimes. I'm also going to order that you not have any contact with Russell Rondo. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. Given the praxis scoring at a risk level 2, which is released with conditions and supervisions, I think we can meet that requirement with the no contact order. I'm also going to order that you enroll in community corrections services. I will release the defendant on a personal recognizance bond. Mr. Burns, before you are released from jail today, you'll be receiving your next court date. Make sure that you make note of that court date. And then you'll also need to come over here to the courthouse and get signed up for services through community corrections. All right.
Right here, Your Honor.
All right. Thank you. Thank you, jail. All right. This is case number 254915SD. We are here for an arraignment on an amended complaint. Mr. Harrison, were you aware of that?
I just became aware of the circumstances that gave rise to the need to rearrange hers. I'm using the term loosely because it's my understanding the charging document is not changed at all except for the effective date or the incident date. I'm not sure when.
My understanding is that we are amending to change the incident date.
Yeah.
So, Ms. Horton, I have an amended complaint that now alleges that on the date of November 20th, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of operating with a high bodily alcohol content. That is a misdemeanor punishable by up to 180 days in jail and or a fine of $200 to $700 and or 360 hours of community service. Rehabilitative programs, vehicle immobilization is mandatory of the prior, and reimbursements for the cost of prosecution, governmental expenses. In count number 2, it's alleged that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilization with a prior, and costs for prosecution and governmental expenses. In count number 3, it's alleged that you committed the offense of failed to report an accident to fixtures. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100. You understand those charges and potential penalties? So as I said before, the only thing that changed is the actual date of the incident. You do have the same rights that you had when you were originally arraigned, including the right to have an attorney during this case. We will continue the appointment and enter the not guilty plea. I guess since we're here, is there any resolution to this case at all?
I made a brief inquiry with Mr. Morris. Apparently, we're still waiting on labs.
All right.
Provide another wordy answer to your simple yes or no question.
And I don't believe we've had a pretrial on this. Oh, we have. We're set for final pretrial on the 22nd.
That shouldn't be a problem unless we have further delay in getting the labs.
All right. All right, Ms. Horton, just a reminder that we are still set for the 22nd and that your bond conditions continue.
Okay.
All right.
Could we seek to remove the condition that she be tested for drugs randomly? She's doing the daily breathalyzer, which we fully understand given the circumstances of the case. The random drug testing is starting to get expensive.
Ms. Lawrence, do you have any objection to hearing that today?
No.
All right. Mr. Harrison, do you know how many times she's been tested for drugs?
At least 3.
At least twice a week.
Okay,
Since then,
last time I talked to you.
yeah.
For both and drugs and alcohol?
Yeah, she's blowing 4 times a day on the breathalyzer.
Okay, so you're blowing the 4 times a day and then you're coming in twice to do a urine
Yeah.
test? All right, Ms. Lawrence, I do not have any things in my file. Do you?
I do.
Argument?
I'll leave it up to the discretion or.
All right. Based on defendant testifying today, or at least stating today that she's been testing 2 times a week and we have had no positive tests for controlled substances. It looks like she's been on bond since November 21st. The court will go ahead and remove the drug testing conditions.
Thank you very much, Your Honor.
All other conditions will remain.
Yes.
No problem.
That's it for the arraignments. Until 2.